Okay, everyone, Level Up Law is live. Welcome and thank you for joining us today. We're here at Legal Services every Tuesday at noon. We are leveling up your legal knowledge on the different areas of law that we handle on our Level Up Law show. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I'll be the host of the webinar today, along with producer Kenneth Elliott from our IT department here at SCLS. We are joined today by attorney Heather Faulkner from our office in Greenville, South Carolina. Heather's going to be discussing school expulsions, an important topic in the education law field. As you view today's presentation, remember this is not legal advice, but just general information for the public. Always consult with an attorney if you have any specific legal matters that you have questions about. At the end of today's presentation, we will provide information on how to apply for our free legal assistance here at South Carolina Legal Services, as well as how to access our public information and other resources. As always, a recording of this webcast will be posted on our YouTube channel for South Carolina Legal Services later this week, and also with the slides that Heather will be using today. Now, even though you'll be in listen-only mode, please be sure to take advantage of the opportunity and put any questions you have in the question box that you see. As time allows, Heather will provide some general information to hopefully answer your questions. Again, thanks so much, everyone, for joining us. And Heather, let's get started.
Thanks, Susie. I'm excited to get started. I appreciate the introduction. As Susie said, we're going to be talking about school expulsions. I'm a staff attorney here at South Carolina Legal Services, and it's important for you to really kind of understand what goes on in the school, what your rights are when dealing with expulsions, and just having a good idea of what to expect in that process. To start off with, if we just jump straight to expulsions and don't discuss suspensions, it would be a disservice to you. An easy way to remember some of your process for suspensions is to remember 10-30-10. You can be suspended for 10 days per offense, 30 days altogether for the school year, and then your last 10 days of the school year is kind of a free zone in that you can only be suspended in the last 10 days if there's an actual threat to your presence is an actual threat in the school, or a hearing is scheduled within 24 hours of the suspension. If the suspension is going to make you ineligible for credit, these are the only ways that they can suspend you during those last 10 days. So remember, your presence would have to be an actual threat, or a hearing would have to be scheduled within the first 24 hours of the suspension. One thing you need to remember is we're saying hearing. For a suspension, you're talking about more of a give and take conversation. It's not going to be something where you show up at the courthouse and you have this very formal get together with a judge. It's going to be a pretty quick process, and we'll talk a little bit more about that. So when you are being suspended or facing a suspension, you are supposed to get notice in writing. It is supposed to tell you what you did, and you are supposed to have a conversation, that hearing, and it is supposed to take place within 3 days. That suspension can be appealed to the Board of Trustees or any authorized agent. To find out what that process is specifically, you would need to look to your district policy. Each district is going to handle things a little bit differently. You'll want to look at your policy manual that you get at the beginning of the school year, the handbook, to see what exactly the steps are in order to appeal your suspension. You can be suspended for a couple of different things. You don't always have the right to see an attorney when you're facing a suspension. One interesting case that we've seen come up through the courts is a case where the student was actually accused of drinking alcohol before coming to a football game. He was given notice of the suspension and had his conference at the same time, and the court said that that was okay. So if the the principal or assistant principal, whatever agent of the school, is coming up to you and letting you know that they're wanting to suspend you, and then proceed to have a conversation, a give and take conversation with you, that's appropriate and allowed according to the courts. You can appeal, like I said, to the Board of Trustees or the authorized agent, but you can't appeal the actual suspension into the circuit court. This is making it go from a decision that's involving the school and the school board. You can't then take it and put it in a formal court setting. However, there are some circumstances where you might be able to appeal the investigation of the suspension. So for example, another case, Doe v. Barnwell, the students were accused of inappropriate physical contact on school grounds. Officers were involved. They were suspended for 5 days. And the students wanted to appeal that suspension. So they went through the school process for the appeal, and then they were able to take it into the formal court system. The reason they were able to do that is because they were not actually appealing the suspension itself, but the investigation that the school went through. So they were saying that the way the school investigated the situation was inappropriate, and so that was allowed by the court. But that's an important distinction. You can't take a suspension and enter into the formal court system. You're going to have to look at your district policy, your district procedure, and go through that process in order to appeal a suspension. So you do have some rights during your suspension proceeding. It's important to note what is the parent's right, what is the student's right. The student has that right to have a give and take conversation with the school administrator. That is likely going to be the hearing that you have. You also have the right not to give a written statement. There can be consequences to that. You can wait until your parent arrives, but the student should understand what those consequences are before making that decision. The parent does not have a right to have that conversation with the school administrator. That is going to be solely between the student and the school administrator. The parent does have a right to get a copy of that written notification of suspension, and at that conference, the give and take conversation has to be scheduled at least 3 days after the suspension. So if you've gone longer than 3 days and you haven't had a conversation with that school administrator, then you might have a claim you would need to talk to an attorney. The parent does have a right to appeal that suspension to the school board or designee. Again, you would look to your district policy for that. You would want to look at the school policy. Some schools, there are situations where maybe an assistant principal will issue the suspension and you only have the right to appeal to the principal. Other schools may allow you to appeal all the way to the district office or the school board. So you would just have to take a close look at that for your district. The parent also has the right to remove any false or misleading statements from the student record. You should definitely take a look and see how long the school is going to keep those discipline records. Make sure that everything is written in a way that it is true and not misleading. You can also file a complaint. Parents can file a complaint against a teacher in addition to the school board complaint. So if you really see something that you're upset about, you can definitely look at filing a formal complaint against any school administrator and following the procedures that way. You can also agree and consent to a right to transfer. The right to transfer allows you to consent to the transfer in order to avoid a suspension or an expulsion on your record. If you do not consent to the transfer, then you have to have that conference or hearing, that give and take conversation. If you agree to that right to transfer or it's denied, you can appeal that decision to the school board. And again, you would just look at your individual district policy in order to do that. If you, from a practical standpoint, if you agree to that transfer, there's some chance that the new school is going to agree with your child's discipline record. So just because you're moving from one school to the other doesn't mean that you get a clean slate. That discipline record is going to follow you. And there is no right to appeal a transfer into the formal court, because this is not actually written into the statute. So you have a right to appeal again with the school board, but you're limited just to dealing with that informal process. You're not going to be able to take it into a formal court setting. So that's something to be aware of. So now we're going to get into a little bit of expulsions. Hopefully you see a little bit of the humor with the Harry Potter reference, but in reality, expulsions are very, very serious. Children have a right, and they are given that right to a free and appropriate public education. It is a property right that the courts have recognized, and so they are required to provide some sort of due process. You can't just be expelled without having certain steps taken in place first. So it's important that you know your rights and understand the process. We do have a statute that lays out clear reasons you might be expelled. One of the most important ones that we see here is that you must be expelled for a term no less than 1 year, so at least a year if you bring a firearm to school. This expulsion term can be modified by the district. The district can make case-by-case decisions, but the statute is pretty clear that if you bring a weapon to school, a firearm, that you're looking at an expulsion of at least 1 year. The individual school boards will have their own policies that will require them to refer any student who has brought a firearm to school to the Department of Juvenile Justice or the representative. So it's possible that if you bring a firearm to school, not only are you going to face the expulsion through the school district, but you could also face some of those criminal charges as well. You can also be forced to go to an alternative school. And just for clarification, the term expulsion is defined as being placed out of the school for the rest of the semester or the school year. So suspension is going to be a much shorter term, whereas expulsion, you're looking at the whole entire semester or the year, depending on how long the school administrator wants to enforce the expulsion. Other reasons that you can be expelled is the commission of any crime, whether it's on campus or off campus can be a room for debate, because we also have this gross immorality and gross misbehavior issue that can come up. Typically, when you're looking at an expulsion, it's an incident that has happened on the bus, on campus, at a school event, whether it's on campus or off campus. But there are some cases that you definitely have debates about behavior that has taken place off campus that's not necessarily linked to the school, that the school feels it is responsible for taking action on. In those cases, you should definitely look for an attorney and seek some legal counsel. Our statutes also mention that you can't get suspended for buying a lottery ticket when you're under the age of 18. I thought this was just an interesting statute to include. I think it goes to show some of the mindset of our legislatures. But it is important for you to understand that conduct that is going on at any school event, on any school property, is definitely going to be under the school's purview for discipline, but also remembering that there are some situations where you might think that your behavior is completely disconnected from the school, that it's not affecting the school, and the school could still potentially take action. So in those kinds of cases, I would definitely advise you to seek legal assistance. When you're facing expulsion, it's important that you understand every single right you have. So again, you have that written notification of the expulsion hearing. The hearing is going to take place. It's a little more informal in the beginning. You have to work your way up, but you're going to have a hearing officer, slightly different from formal court, but you definitely want to make sure that if you have the opportunity or you feel that it's necessary, that you seek that legal counsel. If you get to a hearing and you don't have legal counsel, typically what we've seen is those hearings last about 15 minutes. If you have legal counsel that comes with you, those hearings can last up to an hour. So it's important that you really understand what's going on, and that first written notification is going to tell you, when your hearing is, that you have a right to that hearing. The hearing should take place within 15 days unless you request a continuance. And a continuance is just asking the court to continue the hearing to another time. So letting them know that you can't attend the hearing on this day, or that you would like to seek legal counsel before attending that hearing. Keeping in mind that during this time, your child will not be allowed on school property. So that does continue to be in effect. The longer you have to keep pushing it off, the less, the longer they're out of school. Again, you have that right to legal counsel. Definitely want to consider it if you have the opportunity, if you feel that it's necessary, because it does make a big difference in how those hearings go. You have a right to question witnesses at the hearing. You also need to understand that the school is going to be very protective of other students' their right to privacy. There are ways to ask people to come. Typically, we ask that parents come to the hearings, or family members who can talk about the quality of the student depending on the circumstances, what consequences have taken place at home. You can ask if there was another student witness, if they would like to come and testify for your student, but it's very difficult to force them to come in and testify, so you can ask those questions. But in reality, you do have an opportunity to ask questions of the school administrator, whoever is there. So you do have that opportunity during the hearing. Once the hearing is done, you then have the opportunity, or you have the right for the decision to be made within 10 days. So within 10 days of the hearing, you should get a decision in writing, some form of letter or document that will say what the hearing officer's decision is with regards to the expulsion. Either it's going to be upheld or it'll be reversed. If you get the decision and it's not favorable and you disagree with it, once you have completely exhausted the appeal process with the school district, then you can take it into the formal court setting. So again, this is where it's important to take a look at your district policies. You want to look at the school handbook first and work your way up. So if your school handbook says that if the assistant principal can give you that suspension, you have a right to appeal to the principal. You cannot go through the expulsion process and skip the principal. You have to take it step by step until there's no more room for you to take that appeal in your school district before you can take it into a formal court setting. Once you have completed your expulsion hearing with the hearing officer, you have that opportunity, like we've said, to appeal to the school board. This only exists in your expulsion or alternative placement cases. So remember, when we were talking about suspension, you cannot appeal a suspension into a formal court system. You only can appeal those expulsions or the alternative placement. Once you have that expulsion hearing and that's done, you've gotten the decision, you've made the decision that you want to appeal. You can take that through the rest of the school board appeal and then into the formal court system. You can only do this once the expulsion term has been complete. So you have to finish all of your appeal processes through the school board. And then once the expulsion term is over, you're able to appeal into that circuit court. That's just the formal court system. The appeal into that court system is going to be limited to whatever is on the record ahead of time. So this is why it's so important when you get that notice of hearing in front of a hearing officer that you have an attorney present. During that hearing, they're taking a recording, they're listening to the questions, everything's being recorded. So that way, if you decide that you need to appeal into a formal court system or to the school board, that everything has been preserved. If you go into that hearing and you have no representation, you're probably getting your 15-minute hearing. You don't know what questions to ask. You're going to be very limited to what your issues are on appeal. If you have an attorney present, they're going to do their best to complete a full record for you, something that will be helpful when you go into that appeal. Again, this is why it's important to take a look at your appeals process. You definitely, when you look at it, need to make note whether you appeal in person or whether you appeal in writing only. This is something that if you have legal representation, they will help you with, and take a look at that. If you're doing this on your own, you should also consider requesting a copy of the audio. This is that video recording, the audio recording of your hearing officer, and you want to listen to that whole thing. When you get in there and they start with your introductory, you know, this is why we're here today. They're going to ask questions. The school's going to present their side. They're going to give their decision, or they're going to close the case and say they'll give a decision. Sometimes they talk after they've decided that the issue is done for the day. You definitely want to listen to that whole recording, because there may be some conversation afterwards that would be important when you go to that appeal. So we do have some additional resources with South Carolina Legal Services. This is a lot of information to put together, but we do have some nice brochures that allow us to get all the information in a bite-sized portion. The first one is a brochure that discusses school suspension. So we've talked a little bit about that. How do you get your notice? What happens, you know, if I don't get my hearing? Things like that. What is to be expected. And then we also have a brochure that addresses discipline in special education cases. These special education cases can be slightly different. So if you have a student with special education services, there's a different discipline process that has to be done. You have some additional rights, some additional steps that have to be taken. So if you have a student who has special education services and has qualified for those services, they have an individualized education plan, you should seek legal representation or assistance in going about the suspension and school expulsion process. We do have some additional contact information. If you think that you have a case, your student is facing an expulsion, you can do an application for our services at this intake number. They're open Monday through Thursdays from 9 to 6. You can also apply online at lawhelp.org. It is an easy process to go through. They'll ask you some questions. You just fill in the answers, and then your application gets sent in with us. We have a lot of other resources for the public that you can take a look at. Just good general information. Again, none of it's legal advice. You would have to seek a counsel for that, but you can get an idea of what your rights might be, some steps that might need to be taken. Susie, do we have any questions that have come in?
There is one question, which is about questions. Are there certain questions I should ask at the expulsion hearing? And I guess that's, you know, besides about the specific facts of whatever led to the expulsion.
Yeah. So again, we can't give you a list of questions because each case is going to be different. But you would want to ask, you know, if you're looking at your case, you see a particular issue, if you feel like a process was not followed, a school process that's in the handbook, you want to ask questions around that. If you get to the hearing and you're having concerns that is an issue, then I would definitely make sure you focus in on that. Ask the school administrator what steps they took. If you didn't get a notice, you know, let the hearing officer know about that. What steps did the school take to talk to the student? Did they allow them that open conversation where the student could give an explanation? The hearing in front of the hearing officer is not a time to get really angry or combative. You really want the student to, take a moment to really think about what's happened. It's not a good time to get angry and try to defend everything. If the student took some actions that really could have some consequences, then that's a good opportunity for the student to show some remorse. As the parent, if you're there, you can take time to explain that the student understands what has gone on, that consequences have been made at home, what those consequences are. Those are some good, just general tips if you find yourself in that hearing without counsel.
Okay, I'm sure that's very helpful to kind of know a little bit about what to ask if you don't have a lawyer. But as Heather said, we do have this contact information where you can apply online if you are in the situation and you do need an attorney. We do have those intake folks standing by on Monday through Thursday, 9 to 6. So please take advantage of that. And I also want to mention, as Heather mentioned, we do have the online intake. And if you go to our YouTube channel, there was actually a Level Up Law episode about some tips on how best to handle applying for our services online. So I think that can be very helpful to folks if you aren't able to call between 9 and 6 Monday through Thursday. You can take advantage of that online option, and that's I think a really good way to try to get some legal assistance, which we're always happy for eligible applicants we're always happy to try to help folks with these kind of cases in the education law area. We have a really great education law unit here at South Carolina Legal Services with attorneys ready to help out in these type of cases. Well, it doesn't look like there's any more questions, so I want to thank Attorney Heather Faulkner for an excellent presentation on the subject of school expulsions. Very interesting information, and information that probably a lot of people don't have when they get in this situation. So thanks so much, Heather, and thanks to everyone who joined us today. We really do appreciate your interest in the subject matter that we bring to you on Level Up Law, and just always appreciate the attendance. Now, remember, we do this every Tuesday at noon, and the previous webcasts for Level Up Law, going all the way back to June of 2020, can be found on our YouTube channel. You just go to the Level Up Law playlist when you get to our channel at SC Legal Services. And while you're there, if you found Heather's presentation helpful, and I'm sure you did, be sure to give it a thumbs up and share this broadcast with other people that you know may be interested in and may find this information helpful. And also, while you're there, if you go ahead and subscribe to our YouTube channel and sign up for alerts, you'll get a notification every time we post a new Level Up Law episode. So that's really important. If you want to see what's coming up each week, if you're not on our mailing list, which you can get on at our website, sclegal.org, but if you're not on that mailing list, or I guess it's email list actually, definitely check out our Legal Services Facebook page, as well as Twitter, Instagram, LinkedIn, where we always publicize the upcoming episodes for Level Up Law. So if you add us as a friend on Facebook, or subscribe to our YouTube channel, or follow us on Twitter and Instagram, you'll always get those notifications about what's coming up. It's always a great subject matter. And so, speaking of subject matters, next week we will have part 2 in our series about special education issues, and this will be about 18 and over. I'm sorry, I said special education, I meant special needs. If you have special needs children and you want to hear about some of the important things you need to know once those children reach adulthood and are 18 and over. Tune in next week where Mary Lou Seymour and Lanier Sims, who were the presenters for part 1 in that series, will be bringing us part 2, and I'm sure you'll find it to be very helpful and interesting. If you didn't see part 1, circle back to our YouTube channel and take a look at that, and that's a good intro to part 2, which is coming up next week. So, thanks for tuning in to Level Up Law today. We look forward to having you back with us next week. And that concludes today's webinar. Thanks again to Heather Faulkner in our Greenville office. Take care, everybody.